Hello and welcome to EnergyTech Essentials from the Net Zero Technology Centre. We're here in the TechX team trying to share some useful insights to energy tech founders and startups, whether you've just started thinking of your idea, whether you're in the process of building, or maybe you're one of our alumni who've been through our programs. These series of EnergyTech Essentials episodes will hopefully give you a little bit of a dive into some of the key topics that might come up on your startup journey and highlight some of the fantastic partners we work with through our TechX Accelerator program. So today is all about some legal risks that startups face. Unfortunately, as fun as I'm sure it is, there is a lot of legal elements to consider when you're building a startup, and we're delighted to be joined here by Martin from Brodies, our legal partner from cohort 1 all the way back to the start, to join us today. How are you today, Martin?
Super, thank you.
Excellent. Well, thank you so much for taking the time to join us. If anyone is watching along live, feel free to pop a question in the chat. But if not, we're going to go through a wide-ranging discussion about what it's like for a startup in the energy sector and also some of the legal kind of pitfalls or opportunities that come up as well. So, Martin, maybe just give us a brief introduction to yourself. You've worked with a lot of TechX startups over the years. So then what are some of the kind of common things you maybe often see in terms of energy tech startups, the legal challenges they come across with your experiences of working with them?
Sure, yeah. So I introduce myself first. My name is Martin Ewan. I'm a partner, as Edward said, in Brodies LLP, one of the largest law firms in Scotland. And I help companies of all types. I help directors run companies and buy and sell companies, mainly in the energy and technology sectors. And if you imagine a Venn diagram of energy and technology, where those two overlap as well. And I help everything from brand new startups to pretty advanced listed companies with pretty high capital bases. So I've seen it all. I've been also doing this for more years than I would admit to. So I've got all kinds of experience, and I've usually seen it, whatever it is, whatever problem somebody's got, I've seen it in some format before. And in terms of what we see a lot of, it's been a real pleasure helping the TechX program over the last, was it now 7-8 years since it was founded. And again, there are all kinds of different shapes of startup, from some people that have never had a business before to others who are maybe more grey-haired and in the early days had left the oil industry and then started a startup. So they maybe had experience of larger companies or different shapes of companies, but had never been on a startup journey before. So we get the full range. In terms of what we see normally, is, if there's such a thing as normal, the thing that I always say to clients is that law, everyone understands that there's a rule book of law that we have to comply with, but a lot of commercial law is like strategic risk management, and there's a lot of things that you can do to minimize your commercial risk and make your journey easier. And the first thing that I put down, just when I was jotting down some thoughts about this, was the first major mistake that I see people make is not putting enough thought into their corporate structure. I think a lot of people, and I get it, people are enthusiastic and they're maybe not terribly experienced and don't understand the sort of universe of risk that's out there, and they just think they can set up a company on Companies House themselves or through one of these incorporation agents online, and go 50-50 with the shares with a pal, and they're off, and that's the legal bit done. And there's a few obvious things there that people tend to miss. The first is that when you set up a company, if you've only got one company, it's going to have all your assets in there. So let's say you've come up with a great invention that's going to revolutionize the way an industry does something. The intellectual property and the rights to that invention are going to be in that company, and that company is then going to be owned by the founders. And what I often think is, I wish that at least on day one they'd had a think about whether there should be two companies, because I think of a corporate structure. If you imagine a diagram of a corporate structure, like a corporate fuse board, because if some event comes in, so let's say the company goes bust, let's say they enter into their first contract and it goes disastrously wrong and they get sued or something, you can use the corporate structure, and the whole point of companies is that they have limited liability shields. And so if you just take a moment, then it might be that you can keep your intellectual property, which is the valuable bit, in your top company, and then have an operating company below it. And that's the company that enters into the contracts. Now, of course, as with anything else, there's a trade-off. Do you want the cost, hassle, admin of having two entities? Will counterparties like that structure? There are things to think about, but that's one of the main things, particularly if you're in an intellectual property heavy company, as many tech companies are. So that's the first thing, is just really not putting enough thought into that structure, and also thinking about the structure between the two founders, because very often it's two friends from university or something that have come up with an idea, and they like the equitable sounding nature of going 50-50, and everyone's best friends until it all goes wrong. And again, there in that structuring, just thinking out a doomsday scenario, and lawyers are never popular because we're always wheeled in when there's a problem, and it's not great if people have just done the basic documents, they've entered into a 50-50 deadlock situation, because that effectively means that if the two people fall out, the company's paralyzed. And I've seen that more times than you would believe. So again, just thinking that through, is 50-50 the right structure? And even if it is, what kind of ultimate dispute resolution procedure could we have that doesn't result in the company getting stuck together? So that's what I bracket as the first red flag, Edward. The sort of not putting quite enough thought into structuring. And then the next thing, second one, I think, is not understanding the role of the director. So very often, again, in a startup, the entrepreneurs, the founders, are both shareholders and directors. They wear two hats, and just to many people, it doesn't matter which hat you're wearing. It's your company. You own 50% of it. They often refer to each other as partners and so on. They don't really think of it in a corporate world. But the role that you have as a director is fundamentally different, and you have particular duties that you have to adhere to and make sure that the company makes filings and so on. Otherwise, you're personally on the hook potentially for things like that. And also, you owe shareholders a duty. So if you've got a broader shareholder base, let's say you've got two main shareholders, they've got 20% each, and then 10%ers. And if it's the two larger shareholders that are the directors, they can't just act in the best interests of themselves and of their 40%. They owe a set of legal duties to those smaller shareholders as well, and a lot of that just is missed by people, and it can get you in a bit of a jam depending on how things develop. So that's the second thing, is the director's role. The third one is protecting IP. I guess in the corporate structure point I mentioned on point one, it was, part of that is to protect the IP, but I'm just meaning, especially for patentable intellectual property, because it is absolutely crucial. So if you have the kind of invention or intellectual property which might be patentable, then it is absolutely crucial that you keep that confidential. For example, and I had a situation once where a company had developed in complete secrecy an invention. They had only their employees had worked on it, or people that were subject to NDAs, so it was all strictly under wraps. And then, almost at the last minute, they exposed this piece of equipment out in the open for a testing run. And the testing run was essentially done on public land, open air, and anyone walking past could have seen this. And that was enough to knacker the patentability of the invention. And it's heartbreaking. These guys had done all they could for, where it was 5 years building the thing, and then at the last minute sort of made a mistake. So protecting IP in that way, making sure that only if it's a real crown jewel piece of intellectual property, making sure the right contractual protections are in place, NDAs, and so on, and if it's patentable, liaise with patent agents and make sure that you get that coverage as soon as possible. So that's number three. Number four, again, is slightly ties into that, which is the use of NDAs. And that is, so make sure that you're using them sensibly. Now, an NDA is nothing more than a very basic contract that obliges the receiving party to keep confidential whatever he or she is receiving. So it doesn't need to be complicated. Conceptually, it's quite straightforward, but you do need to be careful about that it covers what you want it to cover? Will it just cover what we discussed in this meeting, or will it cover subsequent conversations, email exchanges that might follow, drawings that might be exchanged, whatever it is? Does it apply between us and the company we're speaking to? And what about that company's parent company or that company's subsidiary? What is the scope of the parties that are really intended to be brought into this? And also, and this is one I've seen again more than you would expect. Is there anything sneaky in there if it's their NDA that they give you? Because it should just do what it says in the tin. It should just say we will keep this stuff confidential. But often buried away in a clause, there will be something like, and we'll have rights to do what we want with the intellectual property, or we can do this without your consent. And so you've got to be very careful that there's not a sneaky trap door in there, that there's some intellectual property being pulled away from you, or rights in some way. That was 4. And 5, moving slightly away from the sort of day one things, is when you get to the point where you're contracting commercially with counterparties, whether it's somebody to use a test facility or an actual customer. It's very easy and deceptively attractive when you are a startup to just accept the counterparty's contract. They've gone to the effort of drafting it. It's it's 40 pages. There's a lot of words in there. I'm not sure I want to bother reading it, or I'll have a quick flick. But I'm certainly not going to pay my lawyer to look at it, and just accepting those terms. And we all live in the real world. There are situations where you will have no negotiating room anyway. And it's a very basic question of, if you want to do business with this counterparty, then these are probably the terms you're going to have to accept. Bank loans, for example. Or even just using Facebook or Google's terms or something like that. You're going to get nowhere trying to seek amendments to them. But in most commercial relationships, and certainly commercial relationships where the counterparty is genuinely in it for the longer term and wants to work with you, they'll take on board reasonable comments, or they should be taking on board reasonable comments. And that, if anything, might be a red flag if they don't. So again, it's just reading. And again, in basic terms, a commercial contract, of course, lawyers can get terribly caught up in themselves, and they can be very complex. These things can be 60 pages. But at its heart, it should just state very clearly what is each party doing in return for what payment, when, and what happens to the intellectual property rights, and so on. There are sort of 4 or 5 key commercial questions that you could probably ask yourself about what each company is trying to achieve with this document, and then just make sure it does each of those. Because again, I had one situation where a company had contracted with 3 or 4 counterparties, and they had essentially a solution, a contract solution that they would offer to these parties, and they had accepted the terms of each of the counterparties for each respective job. And technically, in every single one of those, they had assigned all intellectual property to the other party. Now, fortunately, none of those parties ever came to sue on it or to enforce it. But it could have been a real mess, and it could have really gone to the value, because if a buyer had come along to buy the company and seen, hang on, you've technically assigned away the crown jewels, not just once, but in almost every job you've ever done. Yikes. So that's the 5th one. The 5th one is, again, just taking some time to at least run the rule over counterparties' terms and seeing where the big problems are.
Really interesting themes. I think that this will come up in a lot of different areas. I think that's useful. One area that's maybe a side note. I remember one of the things I did relatively recently was, there's all these PPI lawyer things. Did your car get a payment, etc.? I remember I filled in my details, filled in this form, said, yep, I want to know if I've got PPI or whatever it is, clicked send, and then instantly got this legal contract through saying, you've agreed to this contract, etc. And I remember reading through it, because normally I just go, yep, fine, great, off we go. And then it turned out in the contract with some of these terms saying, even if you don't use us, we're entitled to 50% of anything you make, blah, 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 blah. So I ended up doing my cancellations. But it got me thinking, that comes up a couple of your things in terms of both IP, contracts, NDAs. When the startup is really brand new,
Yeah.
One of the first contracts they'll sign is things like possibly software, things like systems, things like tools, maybe AI, and the sneaky terms that are creeping in there that I can see are things like software ABC. You give us permission to use everything you use our software for to train our AI models and other things like that. So, kind of, what are, if you're imagining an early stage two founder team, they're signing up for things. What advice would you give to that early stage, navigating this complex digital systems world?
Yeah, no, a really good point, and maybe AI is a separate, worthy of a few separate words
Yeah.
itself. So for taking it for your first bit of your question, applying it to everything else, I mean, at the end of the day, read them and read them again. And I know, I mean, I would say this, wouldn't I? If you've got any questions, go to your lawyer. There used to be you're probably too young, Edward, to remember the Law Society of Scotland used to run an ad campaign in the late 80s, early 90s that was, it's never too early to call your solicitor. And it is, some disaster would befall somebody, and it was never too early to call your solicitor. And it's a bit like that, because while one person might glibly get away with signing up to all of these things, and nobody ever looks twice at them or enforces them, a bit like the customer I mentioned before, um, the next person could accidentally in the back door have assigned away the lifeblood of the company, the key IP that they've got. So there's no way around it, sadly, but just to read it, and if there's any doubt, get some advice. The AI thing, I think, is fascinating, because that's something that is going to become an ever bigger problem. Practically speaking, I mean, I suppose the shape of the problem is the same, exactly as you said. It's you're contracting with somebody that is likely to be hoovering up rights to your material, so it's the same problem. It's just going to be more prevalent, and people just right now, or up until now, have not really been paying attention to this. I've heard one story of people using AI to zhuzh up a pitch deck for an investment. So they prepared the initial pitch deck. It was zhuzhed up by AI. So in order to do that, they had to upload the existing pitch deck and put a snazzy graphic on slide 5 or whatever you want to do, without really being aware that the rest of that presentation, which was financial analysis of a company, was getting hoovered up into the cloud. So you can just imagine the next person that said, prepare me a pitch deck for company X to this AI tool could possibly get that what ought to be confidential, proprietarial information prepared by someone hoovered back down to them. So yeah, so it's a real live problem, and again, the only thing you can do is unfortunately read the T's and C's.
Excellent. Yeah, lots of lovely reading, but it is important, I think. So then, keeping us at that theme where we're relatively small, you maybe got those early founders. Maybe it is setting up the company as the first thing that goes on. I guess maybe that co-founder relationship you spoke about, maybe not doing the 50-50, and we obviously on the TechX program talked to the startups about having a founders agreement, having a way of actually deciding what is best practice in terms of how you approach that, and is there any kind of common kind of definitely need to discuss these couple of things when you're kind of negotiating that co-founders agreement?
So I mean, to some extent, there are rules of the game, as it were, that you could, in broad strokes, say most people should be thinking about this. But also, it depends entirely on what the individuals are contributing to the startup and what the relationship is, what the commercial bargaining power is. So to telescope out of that a bit and maybe try and answer your question effectively, Edward, I think everyone should put it in writing. That's the first thing, because and there should be an effective dispute resolution mechanism in there. Now, what I mean by that is that's some long legal words that just means there's a get out clause that says what happens if everyone falls out here. And it might be as simple as, take that 50-50 example. It might be as simple as we have to go to court and potentially wind up the company. Some people might choose that as their default because they think that will force them into compromising or reaching agreement and never letting it get that far. Again, let me tell you, I've had clients that have got that far several times, so I'm not sure of the effectiveness of that strategy. But what you could have, for example, is I think it's called a Mexican shootout, where if you've got 50-50 shareholders, you maybe have an escalation procedure where if we can't agree in a board meeting about something, then we escalate it to, and if they have an independent chairman,
Mhm.
or then the chair might be able to say to resolve it.
Mhm.
If not, we could put it to a third party. Just
Mhm.
ways of unlocking it. And ultimately, if none of that works, then you could have a situation where either party can offer to buy out the other,
Mhm.
and the person that receives the offer can either accept the offer or turn it back and buy the other one out.
Mhm.
So
Okay.
it's a corporate version. I don't know if you ever played the game when you were a kid, at party games where one kid would cut the cake and the other kid would get the slice. So it's keeping them honest, because
Mhm.
if you genuinely think that 50% of this company is worth X, then you'll be happy for either to buy the other party
Mhm.
out or to take that and walk
Mhm.
away. So yeah, so dispute resolution mechanism there. Um, Understanding what the decision making within the company is for
Mhm.
while it's operational. Again, if you've got two founders, it's typically you're both directors. Again, so what if you disagree? You're sitting at the boardroom table, you
Mhm.
can't agree whether to take this overdraft or chase this customer. How do you resolve that? Could an independent chairman be a solution?
Mhm.
Um, that sort of thing there. And again, if you've got a broader shareholder base, let's say there's five of you,
Mhm.
it's nice and easy. If it's an odd number, I suppose
Mhm.
you can just resort to majority rules.
Mhm.
But that's another example of where you can't. There's not quite a one size fits all, because it
Mhm.
depends what you want. And the last point, I suppose, is being clear on what everyone's contributing, because not everyone will be bringing the same value. You may have a commercial partner, and you may have a technical partner, and you may have somebody that's bringing some cash, and it's just sort of intelligently
Mhm.
sitting down and making sure, right, we know what we need from member director A,
Mhm.
we know what we need and want from shareholder
Mhm.
director B, and we know what we want from shareholder director C. Do the contracts actually give us the ability to effectively get that, or could one of them freewheel? Could one of them not actually put his
Mhm.
shoulder to the wheel and bother,
Mhm.
opening up the contacts book he's got, which is why we brought him in, or not quite advancing the money quickly enough? So again, it's just making sure that this is thought about, and that there are the proper contracts put in place to make sure they can do that.
Excellent. So I can imagine a big planning meeting taking place, a lot of what if scenarios explored, but then eventually getting that written down. So there is this formal written aspect. Again, sticking with this early stage, and again, these are quite broad questions, so it won't be perfect for every startup. But if there was a to-do list of a relatively early stage company, because a lot of the legal responsibilities of those directors trigger from day one. You know, as soon as
Yep.
their company is formed, there's a lot of legal responsibilities, and early stage founders might not know all the different aspects need to consider. So if there was a to-do list of things to think, right, we're going to need a privacy policy or terms and conditions on our website or a draft employment contract or a shareholder, what are some of the top things you'd be thinking, right? Even from day one, I think you should be talking to your lawyer or getting this set up and ready so that you're legally compliant.
Um, so you've touched on a couple there already. So the when a company is set up, it has articles of association, which is
Mm.
essentially the constitution of the company. So if the founders have not agreed on a specific bespoke um, constitution, then the Companies Act specifies, and you get a default constitution. So that's the minute one
Mm.
point, that you get this constitution whether you want it or not.
Mm.
Again, an intelligent conversation about whether it's suited to what you
Mm.
want to do and where you might want to change it. Then the next one is probably the shareholders agreement that we spoke about, founders agreement, whatever we want to call it. Just that, again, that next layer of detail, which is the contract between the parties about how
Mm.
things are going to work in practice. And just to make a comment on those two, the articles are publicly available,
Mm.
so they are filed at Companies House online, and anyone can see what kind of articles a company has. The founders agreement, shareholders agreement, that's entirely private to
Mm.
the parties. So you can keep, if there's, for instance, financial details or personal details or whatever in there, that could be kept confidential in there. So those are, with regard, those are sort of day one things. Employment contracts is an interesting one, because, and I see a real tension here, because strictly speaking, under the Employment Rights Act, every employee has a right to written terms of employment. But with startups, every penny's a prisoner,
Mhm.
and in many cases, the company probably can't afford to pay the individuals anyway. So that's one that I think candidly is honoured often in the breach,
Mhm.
uh, because but again, a director should be getting the directors, the board as a whole, should be getting proper advice so that they
Mhm.
know which risks they're running. So
Yeah.
that even if the answer is technically you should have an employment contract for all five of you, and they say, oh, that's going to cost us, a few hundred to a few £1,000, and we don't have that right now.
Mhm.
You know, at least they're going into it with their eyes open. They're not adhering to their legal
Mhm.
duties. So it's a question, I think, there again, of just knowing strategic risk management is at the heart of this.
Mhm.
And I think that's it. As long as the directors are advised and they
Mhm.
can make the decisions and the trade-offs, then that's okay.
Yeah. Is there any best way? This will probably come up throughout, but knowing what those responsibilities are, knowing what laws change. Obviously, having a great lawyer is definitely a start, but equally, you don't know what you don't know. So you don't know to call your lawyer to say, I don't know if I have this. What mechanisms should startups be paying attention to know? Oh, often we hear things in the news. Oh, there's been a new change to employment rights, so there's been a new change to data
Yeah.
protection rights. So how do they keep on top of it all?
Yeah, I mean, it's a constant challenge, and it's constant challenge even for us as lawyers to keep on top
I
of the
bet.
constant changes.
Mhm.
Um, so I think the first thing it says there's a huge amount of information available from
Mhm.
public, reliable public sources. So, for example, Companies House itself has regular blogs and releases that when there's information updates. So just now, one of the big things that any directors listening to this, watching this, should be aware of is the new IDV changes. Now, what that
Mhm.
means is that every single director of a UK company and every member of an LLP has to verify their ID to
Mhm.
Companies House, and that involves essentially an online process. I mean, if you're a UK resident, then I
Mhm.
think it's reasonably straightforward. You take your either passport or driver's license and do it through an online portal for Companies House. But of course, if you live overseas, have an overseas passport or something that's
Mhm.
not quite compatible, then it's a bit more challenging. And there are it's not something lawyers do. It's third party tech service providers that do it. But that's an example where there's been a big sort of mailing campaign and to make people aware
Mhm.
of it because there's a compliance issue. So it's signing up for all these newsletters. If you're using reputable and decent commercial lawyers and accountants and indeed patent attorneys, then they'll probably have, we for example, you can opt in to receive different types of legal update depending on your areas of
Mhm.
interest. It might be family law, it might be commercial law, whatever it is.
Mhm.
So again, most major firms and of lawyers and accountants will have that available as well as the public sources. But it's a challenge.
The other element that maybe comes in is we've touched a little bit on compliance and kind of, I guess, it jumps to worst case scenario, but what is best practice in terms of keeping track of all of this? It's a bit like when we talk to the accountants as well. You think of the old fashions, it's all your receipts are shoved in a box and it's eventually handed over. I guess the same with, not the same, better with legal, but you need copies of these agreements. Should you be keeping your terms and conditions that you sign up to? What happens? What's best practice for how you make sure that if you do breach, then you've got the paper trail you need?
Yeah, so I mean, normally, if you start with the basic documents at the start, again, you've got so a company is obliged to keep a set of what are called statutory registers, the company books, as they're conventionally called, and that is essentially the key documents of the company. So, certificate of incorporation,
Mhm.
the articles that I mentioned, register of members that says who all the directors, sorry, register of members that says who the shareholders are, register of directors that says who the directors are, and that's the official
Mhm.
record bible of the company. So what's normal is that if there's a shareholders agreement as well, a private one between the members, that usually gets stored just for practical purposes within
Mhm.
within that, and that should be kept. Well, it has to be kept in accordance with law at the registered office of the company.
Okay.
So that is the sort of first repository of important stuff. Now, most companies these days have a shared drive or something between the founders and the members, or some sort of corporate place where they can stick that as well, a digital copy. But the main ones should be kept under in terms of the Companies Act at the registered office. For other stuff, and this is something that we're seeing AI again coming into, for other stuff, it is just a digital repository. You're absolutely right, and it's folders and subfolders for client contracts, for funding agreements, for employment contracts, and of course, as the company grows and grows, those become ever more complex. But there are solutions out there. One that we're working with, working on with a client is called Amelior, and it's essentially an AI tool where you can store all the signed documents, and it can pull out trigger dates. So is there does the lease, is there a break option in the lease, or a point at which the rent can be renegotiated? So it can flag key dates, or it can just be used as a digital filing system. It can actually be used to negotiate terms, and this is the stuff where I think we're getting to the sort of cutting edge of legal practice right now. This is going to be the really interesting stuff, because when you get a contract from a counterparty, these tools are going to be able to review them and say, well, 80% of this is pretty much the same as the last set you signed up to, but have a look at clause 2, have a look at clause 5, and here are some proposed counter revisals for you to think about. So how this evolves and how that interacts with legal advice is the hot topic just now. But again, it gives you an example of a digital environment where those documents could be stored safely and securely. So digital solutions are probably likely to be the answer going forward.
Yeah, that was definitely a topic I was interested to hear your opinion on all these AI tools. But I think it's important that, where founders are using them, there is that record where they know where everything is. I know when we take startups onto the program, there's a lovely big list of, can we have a copy of this, a copy of this, a copy of this? And, you do see startups say, or even a year post TechX, they go, can I have a copy of that agreement? Or I don't remember if I've got a copy because it's in an email somewhere. So having those structures in place might save you a lot of Googling or searching in your inbox a couple of years later. But I guess from that legal point of view as well.
And the other thing is, again, it's not really a legal point so much as a information security point, or maybe a disaster recovery point. But if you've got these items in an environment, let's say it's a subscription service that you've got just now, and one of the founders is responsible for managing all that, because there's usually one clever geeky guy that's all over that stuff, and he's doing it for everybody. If he's the one that goes under a bus, or he's the one that you fall out with, then how do you get it? So again, it's just thinking around the corner of, okay, so should two people have the password? Should there be double signatures to change it? All this kind of stuff.
Yeah. So I'm now getting a good sense of what the foundations of maybe early stage startup should be. You've kind of got your articles, you've registered, maybe gone with a holding company and an operating company. You've maybe started to think about that shareholders agreement. Now, let's say they're getting a little bit more mature. They're bringing on some employees. They've maybe raised a bit of investment. Probably lots to unpick, and new legal elements come up there. But probably a big one for startups is things like field trials and industrial testing, and maybe they're starting to work with potential customers. So what do things like, maybe let's take a field trial in energy, for example. That's probably one of the big first shiny things they want to do. Is, we've got our prototype, we want to test it on your site, we need an agreement. What are some of the things that startups should be looking at in terms of how that legal relationship should work? And possibly adding into that the sort of David versus Goliath, that point you said about, feel free to push back when you're working with a big energy company and you're a little startup and you desperately want to be testing on their site, but they've got these teams of lawyers. What things should they be thinking at in that stage?
Yeah, really good question. So, and I think you probably, we've helped some of the historic TechX pioneers do exactly this. So the first thing is maybe the obvious one, which is, again, checking that the contract is the right kind of contract for what this is. Is it clear who has responsibility for what, who's going to do what, and what, if any, payments are going to pass, or if this is just a genuinely sort of collaborative approach. So that's the first thing, is just reading the thing, essentially the scope of the contract, to make sure that it's the right kind of contract, that the right things are in there, and and then it makes sense, and that all the right things are in there. So who's responsible. We forgot that somebody's going to need to get the bit of equipment from the tender vessel onto the rig. Who does that? So there's that, and the risk of all those things. The second thing's liability cap, essentially. Now, maybe let's assume it's not oil and gas because it has its own sort of mutual hold harmless knock for knock liability regime. So let's assume it's not an oil and gas thing. Then you want to be absolutely crystal clear what if your bit of kit is going to be testing. Let's say it's a wind turbine, an onshore wind turbine. What if your bit of kit going on there knackers the whole thing? Could you be on the hook for millions? So liability caps. So what are you liable for, and up to what amount? And then next one on that, and again tied into that, is insurance. Are there insurance obligations on you? Because many companies won't do business, particularly with a startup, without ensuring that they've got a sufficient kind of insurance cover and seeing evidence of it. So actually, you often have to say, I have public liability insurance up to 5 million, and here's my certificate provided by a reputable insurance company to show that that's what we do. So those are the kind of things you would think about. Is the scope correct and clear? Are any payments correct and clear? How's the liability apportioned, and who's liable for what? And crucially, what's it capped at? And then insurance as a, I suppose it depends which way you look at it. Insurance in some ways it's almost like a shield in front of you, so you can maybe be a little bit more relaxed about the liability cap if you know you've got effective insurance cover that backs. And the last point I would say is again, these things often come full circle back to our very first point about the two company structure. If fundamentally you're in a David and Goliath situation, and you have a company which is saying, okay, I'm going to give you the opportunity to put your bit of kit in a really high risk environment because it's what it needs to test it. You know that if this thing goes wrong and it blows up, could be catastrophic losses for the other counterparty, and they won't bend on the liability cap, or they won't bend on the apportionment of liability. Then one other way of addressing it could be to use a new company. So you set up a subsidiary, an SPV, a special purpose vehicle, effectively a project company that you can afford to lose if it goes horribly wrong. Now, any counterparty worth their salt will, of course, do due diligence, have a look at that entity, see whether it's got any assets, whether it's worth taking that risk on. But it's just another thing again to think about in the strategic risk management discussion.
Yeah, that's very helpful. And I'm thinking around imagining the startup is going to go forward for this maybe trial opportunity. Let's stick with that. Maybe from your point of view, then, from a lawyer, because the startup maybe doesn't know all of the things that could or shouldn't go in a contract, and maybe hasn't thought through all the questions. What does a dream client look like to you? How prepared should they come? What kind of information should they be giving? How well thought out is it? Like, yeah, what is your view on the outcome is we need to do a trial agreement document between you and that organization. What good things can a startup founder do to work with their lawyer to get the best outcome at a good cost, rather than possibly running up a big bill by being unprepared? Or
so using lawyers effectively, I've got a former colleague of mine who's always spoken about writing a book on this topic, because the worst thing that I think you can do is to drip feed information and elongate the time span involved unnecessarily, to sort of come in half baked, because that inevitably, if you've only got half the information, then you've got to try and fill the blanks by imagining risks that might not be there, or asking questions that might be answered if you had the further document or further piece of information. So I think that's the first thing, is so to be prepared. Take all relevant documentation. So take the field trial. If there's a proposal document that if we assume, take your field trial example, Edward, so you've got presumably a technical proposal document that was the starting point of the discussions, any relevant material correspondence between them in the meantime, and then the draft agreement, so that at least as a starter for 10, you could have a look and go, okay, I understand what this contract is meant to do. We've got a scope set out in a technical proposal. We've had some adjustments or some key points discussed, so it's got to do all those things. And then it's just a question of the lawyer using their experience to say, I've done 5 of these before, so I know that the roughly the shape of these, and then it's a case of identifying, right, the following things are missing, or the following things are not really acceptable, and of those you could certainly push back on these ones and get away with it. So that's the thing I would say. Definitely come early, as early as you can in the process, but fully armed with information. And again, the more concentrated the time can be, the better, because we're all human. If you sit down and you dive in, I was thinking, like Minority Report, where he's moving the documents in his screen. At some moment in a transaction, or when you've got a group of documents and you've got them all in your head, it's quite easy to jump between them, and you can imagine the cross references. You leave it even a week or 2 weeks, and the memory's faded a bit, and you have to go back and read the document again, read the contract again. So those things all just inevitably add time and therefore cost.
And it might be very similar, but building on that theme. So that was looking at a field trial example, another big contract that I guess startups will have and want to use hopefully regularly is their sales contract. They're actually going to sell a piece of their kit now. What are some of the considerations they need to have to get that document or series of documents, I guess, up to scratch? What should they be, again, talking to the lawyers about? Or
So again, I mean that's maybe not quite a day one thing, but it's probably shortly after, certainly when you're at the point where you've got a product ready to go. I mean, I've advised clients that have used online tools to that was in a consumer facing a business, but they use an online tool to prepare their T's and C's, and I was maybe because I'm cautious by nature, I was quite skeptical about how they would look and whether they'd be fit for purpose, and they absolutely were. So again, and this is AI is going to improve this, and I've had clients that have used other companies' online T's and C's, so you can go online and see, oh well, major company X has published their terms of business on there. I'll just use those. Now, I can't condone them from it's a breach of copyright to do that, and you're running that risk, etc. But there's nothing stopping you from looking at those things and certainly using them to inform what goes into these things. And in a sense, you'd be daft if you've got access to those things. You'd be daft not to, particularly if it can give you some sense of what your competitors or what your marketplace might be doing. But I would say start with T's and C's. There are two. You need to probably split it off into two terms of sale if it's goods that you're selling, a physical product, and terms of service if it's services that are being provided, because they need to deal with slightly different things. But it's probably a sensible thing to, once you have a clear idea of how you want your business to run, and what is your payment period, how quickly do you want to be paid, how are you going to deliver these goods or services, how are you going to actually agree a project or a pricing proposal. That once the workflow for your business has been thought through, then how do you enshrine that into a set of T's and C's that all plug in nicely? And again, the lawyers, I mean, commercial lawyers that do this every day of the week. It's not. I'm more a corporate lawyer than commercial contracts, but those lawyers, they're doing these every day of the week, so they'll keep you up to date, all the right statutory references and so on, and that could be done on a relatively cost-effective fixed fee basis. And of course, as you go along, you'll always have a customer that doesn't like your T's and C's and wants to amend clause 25B or put in their clause 47A, and that's fine. You can just take the advice at that time and see how big a risk does it look like it is. So
yeah, that makes sense. And let's hope it doesn't happen. But one thing that, and maybe you can tell me whether it does happen that often, is contract disputes or breaches, or the negative, it hasn't worked out and the startup does want to challenge something or is being challenged. One, does that happen often? And two, what are the processes startups should have in place? Because it probably could be quite scary or challenging to go, this, they haven't paid us. We did sign an agreement with the supplier and they haven't delivered it right, or the customer hasn't paid us on time. How do they navigate that when they're a small venture?
Yeah, so it does happen more than it should. I mean, not within. I mean, in the work that we do with the TechX companies, it doesn't seem to happen that often, and I think that's because the environment that they're in, most of the counterparties are also supportive, and they've got reputations to worry about. But out in the real world, it absolutely happens. It happens more than it should. So things to think about again. I always look at things in a strategic risk management lens. So if the risk is non-payment, if that's the risk you're worried about, then what are the risk responses? Well, the risk responses might be mitigate it. Okay, how do we mitigate? Get some money up front. Get a deposit in. Get payment milestones agreed where you're getting paid in increments rather than it all coming in 6 months' time. So that helps your cash flow and it helps your risk because you'll know earlier if they're not good for it. And if they're not going to pay, then you have an opportunity to suspend performance or something and not get yourself into the hole that you're in if you've done 6 months, 12 months, 18 months of work and then they don't pay. So that's the first thing. Thinking about strategic risk responses, is it how do you mitigate the risk? And included in that might be or transfer the risk. Could you get a guarantee, a parent company guarantee, for example, if you don't think that it's the specific company that you've got that you on the other side of the contract, if you don't think they're good for it, can you get a guarantee either from a parent company or from their bank or something? Now, whether these are commercially agreeable to them, again, because you've got the David and Goliath problem, probably less realistic, but I'll mention them in the interest of giving a full answer. And then in terms of what do you actually do, again, speak to your lawyer as early as possible. Firstly, in your contracts, do you just want to leave it that it goes to court? That's the default. Obviously, if nobody agrees anything specific, then you have to trot down to Aberdeen Sheriff Court or the Court of Session in Edinburgh and raise an action, and you've got the burden of proof. Now, I say you've got the burden of proof. That's not necessarily that difficult if it's quite clear you've got the contract, you've got the invoice you raised, and you've got the evidence you did the work. It shouldn't be that difficult, but it will cost quite a bit of money, particularly if you have to go to Edinburgh and pay not just solicitors but advocates, the Scottish equivalent of barristers. So there is a natural disincentive to having to go down that route. The other thing about that is it's public, so any spat will be out there. Now, that might work to your advantage if the other person values their reputation and doesn't want to be seen to be screwing over the little guys, maybe. But the other thing you could do is you could have an arbitration clause. I don't know if you've come across that, but essentially private dispute resolution, where instead of it going to a court and a judge and it's a public process, you agree that it'll be dealt with by an arbitrator who is effectively a paid judge, and he will hear submissions. Now, when those systems were sort of set up, and one of their selling points was that they would be quicker and cheaper and better access to, or easier access to justice, that sounded great. But the reality is now that arbitration has become very much like court. So most people, if they're in an arbitration process, they'll still employ solicitors and maybe advocates, barristers, to make submissions, and the judge has a formal process. So you end up, in many cases, having as much work to do and as much cost in terms of legal expertise to get to the end point. But it is private. That's the one major thing. So, and I think your question was, on what should you be doing on deal? So I guess thinking about what's in your contract, if things go wrong, if you need to sue, is it just court or is it an alternative dispute resolution in some way? It's thinking about, do you, for example, have the Late Payment of Commercial Debts Act? So there is a provision, a statutory provision, that you can claim enhanced interest if there's late payment. So making sure you're taking advantage of that and that you know about that to be able to do it. And then, I mean, back to fundamental mismatch of negotiating power. I'm afraid there's no way of getting around that, and big companies can afford to string these things out and pay armies of lawyers, pay armies of billing teams to argue about that your
Mm.
PO number wasn't quite right. You've got to resubmit it, and that'll start the 180-day clock again, and so on, and just string it out and out and out. And I'm afraid that is a real world thing. So I guess the only answer to that is do business with ethical and decent people. And I think having the personal relationship there is probably the most important thing.
Very helpful. We're almost running out of time, but I think a couple other things that may be worth just picking up on is, again, for startups at this phase, one of the other kind of contracts agreements that they might sign up for is things like grant funding, government grant funding, maybe even angel investment. What are some of the kind of legal things to look out for when you're possibly signing up to, various different grants or schemes?
The grant funding stuff is usually reasonably straightforward. Again, I've got experience principally in relation to either industry academic collaborations where funding's been drawn down, or technology or energy infrastructure projects where I've got involved in grant documentation. Most of it's pretty straightforward, but somebody has usually got to sign in blood that they'll be liable and give indemnities and undertakings to support that everything that's said in the application is true. And if there's a forward plan as to how the project will be run, that it will be adhered to. And so you've just that one thing. The only thing I'd say with those is just whoever's going to be the signatory just has to make sure, because they're personally likely to be on the line for that. Notwithstanding it's the money going into the company or the project, there's usually an individual that signs it. So that's my comment on grants. And sorry, forgive me, what was your second thing, Edward?
No, I think that I can jump onto. I can't remember if I had a second thing on that one, but that I think that helps with the grants in terms of figuring out. Yep, hopefully the agreements are relatively straightforward, but then keeping in mind those things. This is probably a whole podcast episode in itself, but the other dimension that comes up, I think, with a lot of our startups is the international side. So maybe some of their projects are international. Maybe they have maybe is a bit of a trend now, employees based in lots of different locations and countries. So again, it's a bit of a broad question, but what are some of the pitfalls that might come from operating in international, different types of contracts, different locations of staff, different suppliers coming in? What are the international law dimensions that startups might need to bear in mind?
So one of the one of the things that is quite unhelpful about law is that it operates in a sort of patchwork system. Particularly, you see it particularly in relation to patents, for example. So if you get a UK patent, that's fine. You can maybe get a European patent, but it's utterly irrelevant if you're in Australia or Singapore or whatever. And it's slightly similar here. So if you are a UK company and you have employees overseas, you need to take specialist advice on a number of things. One is what legal system, what law applies to those contracts, because it may well be that an individual let's take Singapore. I just mentioned it off the top of my head. That if you have an employee in Singapore that's working for you, even if he or she is online working on a project that's back in Aberdeen, Singaporean law might give that guy or girl employment rights, and indeed might make your company liable to some sort of taxation because you're employing someone over there. So those are the questions that you need to be very careful about when you're planning where your people are going to be. And in a linked matter from a taxation perspective, one thing that the usual terminology is having a place of permanent establishment, and that basically means, are you doing business on a permanent or semi-permanent basis in that country? And if so, you should be obeying their laws as regards getting a permit to operate there and probably paying tax. So again, if it may seem harmless for you to agree to have for your employee to move to Dublin, but does that mean your company now has operations in Dublin and you're liable to Irish tax, for example? I don't know the answer to that. That was just an example. So those are the things you'd be thinking about: employment rights, and opening up liability to taxation, or indeed other regulatory things where it means that if you've got a person conducting business on your behalf in that country, should you be getting permits for the business that they're doing?
Fantastic. Thank you so much. We have covered a lot there, all the way from very early stage which company do you set up and how do you get those founders agreements, all the way through to thinking about the broader, I think strategic risk management is a really good kind of theme for what we've spoken about today, all the way to possibly going international and hopefully making big sales. Are there any other kind of legal topics that, you know, often come up that we've not picked on today that you would think, okay, we haven't mentioned this, but definitely be aware of this?
I don't think so. I'm just, I often think lawyers are often the doomsday prophets. Always like, oh, but what if it all goes wrong?
Yeah.
And I guess that is inherent in the job because we're always trying to protect people from getting themselves into a mess. But most of it isn't like that. Most of it is, as I said, strategic risk management is exactly the right way of what is the next best step for you. You've got options. Let's help you analyze the options and move the business forward. Legal should not be, the Department for the Prevention of Business. It should be facilitating business in a transparent and sensible way.
Really helpful. Well, thank you so much, Martin, for your time, and thanks for
Pleasure.
joining us on our EnergyTech Essentials series from the Net Zero Technology Centre. Martin and Brodies are one of our valued partners right from cohort 1, so they've been there, seen through it all, and along with various other partners that you'll hear from in this series of webinars, you'll be able to find out a little bit about the practicalities of what it takes to scale and build your energy tech startup. So thank you so much to Martin. Thank you for tuning in, and we will see you again in the next episode.